predominant focus of our efforts at the moment is the exposure of government corruption, focusing on the incapacitation, effectively, of the judicial process, especially when it pertains to the public right to enforce accountability measures to various government bodies. We're focusing on developing a conceptual model to demonstrate how government bodies systemically obstruct the advancement of accountability proceedings brought against them, the institutional biases and other imperfections or predictable errors in the decision-making process of different court officers, whether they are judicial or administrative. They can assist those entities in their efforts to undermine the rule of law in terms of its empowerment of members of the public to hold the government accountable. We are involved in some public interest litigation through which we're effectively demonstrating these matters that we're developing conceptually. A lot of them have quite tight deadlines, and the matter gets further complicated because it's not a fair process. The different people involved will do everything that they can to obstruct and undermine the due process and the opportunity that we theoretically have to present our case. What we have to do in a lot of senses is crisis management. Whilst we're doing that, we have to continue to work strategically to advance the narrative that we have and to develop the tools that we're developing. We are extremely overwhelmed in terms of the work that we have, in the sense that we're inundated, effectively. The problem that we have is the deadlines are live. Some of them we've already reached and we're sort of playing catch up, and others are imminent. At the same time, we have to find time for recruitment and for induction. It's a little bit chaotic in that sense, but you would expect that from a work environment like this because of the nature of what we're doing. The work is extremely consequential. The cases are fairly high profile and they basically set the law for the areas in which we're operating. All cases are at the highest courts in the state, and some of them are at the appellate courts. They're very serious cases, and they're also groundbreaking in terms of the application of the different principles and the way we're trying to push the law. What we do here will set precedent for not just Australia, but for common law jurisdictions, and we're keen to make sure that the right precedent is set. On one hand, we have the benefit of the law being on our side, the fact that we're bringing complex strategy into the case, and based on where the other side, it's impossible for them to see the overall strategy that we have. They're basically reacting to individual steps that we're taking. We benefit from the information asymmetry, but the disadvantage that we have is that we're asking for extremely aggressive orders against government entities. We're basically taking the role of an ombudsman, effectively, in that we're asking the court to make findings of fact which would only be made on applications brought by regulators. Because we're not the regulator, we can't prosecute them in terms of getting convictions against those bodies. But the way we're circumventing the problem is we're saying that's irrelevant because we can still seek declarations that the issues of fact are the way they need to be for those prosecutions to be pursued. The objectives that we have behind doing that are twofold. One, we will then pressure the prosecutors or the regulators to bring prosecutions against those bodies, because if they don't, we will sue them for breach of their statutory duty. And secondly, we can claim damages for a number of tort law violations based on those issues of fact being determined in our favor. It's a very innovative and aggressive way of proceeding, and you're prejudiced by the fact that the bulk of the judges will be uncomfortable with making the orders for a number of reasons, even though there's theoretical precedent for each of the things that we're seeking, because there's no overall precedent for the ambitious outcome that we're seeking to achieve altogether. That is disconcerting for some judges, because even though it doesn't fundamentally redefine the relationship that the public has with the government at law, it practically redefines it, because so far there is only a theoretical capacity that people have to prosecute the government. It's not something that's done as a practical measure. So judges, a lot of them are uncomfortable with the fact that they're going to be the first ones to authorize something which can be extremely problematic and problematic for the government. The second thing is that there are inherent conflicts of interest, even if they can't be obviously recognized. One of the core issues is that you're asking judges to rule against government officials who were involved in their appointment and who will inevitably be involved in the advancement of their careers. You're seeking declarations effectively against the Attorney General's various departments, and it has direct implications for the Attorney General. In some proceedings, the Attorney General would be a party, or we would be seeking to join them. So there's conflicts involved for the judges. Then most judges have no experience with the level of technicality that's involved in these things. So what normally happens is that we ask for a lot, and the courts will basically block 70-80% of what we're asking for initially, depending on who the judge is. What will go through will already be terrible for the government, because the 20% is already the higher end of what is conventionally sought against them. But we will then build a very meticulous case to go after the judges to show how the judiciary is conflicted. That feeds two agendas. One, we want the greatest extent of accountability measures to be enforced against the government bodies. In criticizing the judges or raising criticism, the Court of Appeal then has to settle who's right and who's wrong in a more direct way. The second point is related to our activism objectives. One of the core things that we're interested in achieving is the implementation of an independent statutory code to regulate judicial conduct. That is not a common feature of common law jurisdictions, but recently a number of advocacy groups and government bodies across the world have started recognizing the need for that. In the US, for instance, Congress has introduced a bill to implement a statutory code. Right now, it's a voluntary code that the Supreme Court judges have themselves conceived. But the problem is that nobody actually follows it. It's the same thing with Australia. And the Australian Law Review Commission has identified the need for the code to be implemented. A lot of judges have also supported the notion. We've introduced a petition to encourage Parliament to adopt a code. What we're doing through the proceedings is identifying the need for the code, or the indispensability of the independent code, because in common law jurisdictions, you can't sue the judge. At the same time, whether or not the government takes any actions against judges who are identifiably corrupt is not an accountable process. There's no way this person who's been wronged can take action against the judge in a way that they have definitive rights and can seek recourse if those rights are not respected. The most people can do is appeal the decision, but that's not really an accountability measure against the judge. All that does is it basically quashes their decision or reverses it or replaces it with something else, but it doesn't actually punish the judge who's doing the wrong thing. We're focused on that aspect of the law and the right of people to achieve that. Because of all of this, we have a number of, I wouldn't say enemies because it's not personal, but a number of agencies that really hate our guts and try everything that they can to either jail or bankrupt us or create adverse publicity, everything that they can. We're not just interested in getting acknowledgement about the fact that the government did the wrong thing. We're interested in seeking punitive measures against people who were involved and who didn't do their job. It's not personal, but it's in keeping with a conceptual model that focuses on the use of personal accountability measures against specific officials to achieve overall regulation of the performance of duty by government officials. There are advanced theories that different academic institutions have developed. One has been developed by a professor called Lambsdorff. He's Northern European. His concept basically focuses on what he calls using the invisible boot of the market, the invisible hand in capitalism. He says that you can reduce corruption by creating conflicts of interest for entities that are colluding with each other, because they can't actually go to the court to enforce corrupt contracts. By creating conflicts of interest, you incentivize them to give evidence against each other or to act contrary to each other's interests, and you weaken the association, and ultimately they break because of that. Plus, you disincentivize corrupt alliances.